And we're back on our chapter 12 lecture. We're talking about how legislation has impacted relationship between management and labor employees, especially with different type of unions. We talked about the Fair Labor Standard Act 1938 and its intent. We talked about the Labor Man Relationships Act, the also known as the Taft-Hartley Act 1947, which was replaced later on by the Management Reporting and Disclosure Act, the Landon Griffin Act in 1959. These acts have all have huge impacts when it comes to employment versus management issues. Go back. So this question says, which act in 1938 set a minimum wage and maximum basic hours for workers in interstate commerce industries? Is the correct response A, B, C, or D, or E? This has five choices. If you said C, that is the correct response. Okay, let's continue with labor unions yesterday and today. The National Labor Relations Board was created to oversee labor management issues and provide guidelines for unionization. So this board is put in place to help those unions have guidelines in order so that make sure that the unions are doing things the correct way. Certification is a formal process whereby a union is recognized by the NLRB as the bargaining agent for a group of employees. So again, I'm curious, at your place of employment, do you have a union? And if so, you're represented by which agency? Decertification is the process by which workers take away a union's right to represent them. So if a company or the employees of a company decide that they do not want to be represented by their union anymore, that's known as decertification. Okay, let's look at some agreements or objectives of organized labor over time. First, we have the negotiated labor management agreement or labor contract. This is an agreement that sets the tone and clarifies the terms under which management and labor agree to function over a period of time. So the agreement might say that they agree to meet every 6 months to discuss important issues such as wages and or benefits being paid to the union employees. The union security clause is a provision in a negotiated labor management agreement that stipulates that employees who benefit from a union must either officially join or at least pay dues to the union. So most unions require you to pay union dues that may be taken out of your weekly, bi-weekly, or monthly paycheck, but those funds are used for the operational needs of the actual union. Here are some other union security agreements, such as the closed shop agreement, which specified workers had to be members of a union before being hired. That was outlawed in 1947. The union shop agreement says workers do not have to be members of a union to be hired, but must agree to join the union within a prescribed period. So there are certain jobs where you are required to be part of that union in order to be hired and part of that company. An agency shop agreement is when employers may hire non-union workers. Employees are not required to join the union, but must pay a union fee. So again, when you think about labor, we talk about the auto industry, construction, typically even in teaching, these type of industries are have a huge the unions have a huge impact. So understand what type of agreement you are under with the actual union. Okay? So let's talk more about different forms of union agreement. The closed shop. The Taft-Hartley Act made the closed shop agreement illegal. And again, on this type of labor agreement, employers could hire only current union members for a job. Okay? The union shop So the majority of labor agreements are of this type. In a union shop, the employer can hire anyone, but as a condition of employment, employers hire must join the union to keep their job. So a lot of companies have a union shop agreement. With an agency shop, employees may hire anyone. Employees need not join the union, but are required to pay a union fee. Whether or not you're in the union, must pay a union fee, and a small percentage of labor agreements are this type. Open shop is when union membership is voluntarily for a new and existing employees. Those who don't join a union don't have to pay union dues, fee union contract, or this type. So what we're saying here is that when you look at most of the actual agreements now, it's going to be under what's called the union shop. It's the majority of most union type of contracts. Right to work. You may have heard of right to work states. Well, there are what we call right to work laws, and these vary from state to state. So, this legislation that gives workers the right under an open shop to join or not join union if it is present. Okay, so the Taft-Hartley Act, we talk about 1947, it granted states the power to outlaw union shop agreements. So certain states have the authority or the power to outlaw union shop agreements. Again, with the one shop agreement in which and right to work states that give workers the option to join or not join union if one exists in their workplace. So when you're looking for a job in different states, you need to understand if they are a right to work state. Because typically, if there are certain laws that are going to be present because of that status. Okay? So, since I brought that up, let's take a look at the different type of right to work states. If you see those states in dark blue, these are all right to work states. And that does have an impact on your rights as being an employee working in that particular state. Okay. Now, how do we resolve disagreements between labor and management? We talked about negotiations, but how are these issues resolved? Well, there's a grievance process, a charge by employees that management is not abiding by the terms of the negotiated agreement. So if there's an issue between an employee and management or labor and management, the labor, i.e. employee, has the right to file an grievance that's going to be investigated. Then you have what's called a shop steward, who is a union official who work permanently in an organization and represent employees' interests on a daily basis. So it's that shop steward that's going to represent that employee who has filed the actual grievance. Okay. There's mediation and there's arbitration. So we'll talk about that. A bargaining zone is a range of options between the initial and final offer that each party will consider before negotiation dissolve or reach what we call an impasse. So pretty much it can be a negotiation in terms of benefits, in terms of money, in terms of seniority, etc. So the bargaining owner say this is the range that we have, and we want to negotiate within these terms. Mediation is the use of a third party mediator who encourages both sides to dispute to continue negotiating and often makes suggestions to resolve the dispute. So personal experience, the community college, in terms of the faculty member, and when it comes to management, which would be considered the chancellor, the deans, etc., we've had situations where a mediator was brought in because the two parties could not resolve a dispute, and the mediator made certain recommendations. Arbitration is when the agreement to bring in an impartial third party, it could be a single arbitrator or a panel arbitrator to render a binding decision in the labor dispute. So now with arbitration, we're saying that neither party can come to a resolution, and you have agreed to bring in a third party, an arbitrator, to render a binding decision in a labor dispute. Okay? Now, there are different tactics that a union can enforce when there is a issue between labor management. Probably the most common is a strike, in which workers refuse to go to work. The purpose is to further workers' objectives after an impasse in collective bargaining. So now we've tried to come to a resolution, but for some reason, we still haven't come to one. So with the strike, which we again, as I mentioned, General Motors is currently on strike, and that's when the worker refuses to go to work, and the objective is to come to a collective bargain. Cooling off period, when workers in a critical industry return to their jobs while the union and management continues negotiations. So like during the cooling off period, it's like you're still going to work, but while you're at work, the union representing you and management are trying to negotiate. What's a primary boycott is when a union encourages both its members and the general public not to buy the products of a firm involved in a labor dispute. So again, we're saying that in a primary boycott, let's say if a company makes soap, for example, the union would encourage its members and the public not to buy soap from that particular company. A secondary boycott is an attempt by labor to convince others to stop doing business with the firm that is the subject of a primary boycott. This is prohibited by the Taft-Hartley Act, but I can tell you it still takes place. So this is a attempt by labor to convince others to stop doing business with a firm that is subject of a primary boycott. Okay? So on May 1st, 2020, thousands of Amazon employees called on their colleagues to go on strike after accusing the company of providing inadequate protection during the pandemic. The action attracted considerable media attention, but did not lead to any immediate changes at this company. Do you think this strike could have been more successful if Amazon employees were unionized? So Amazon employees are not part of a union, but they still want to go on strike to express their concerns. Okay. Other tactics include a lockout. This is an attempt by management to put pressure on unions by temporarily closing the business. An injunction is a court order directing someone to do something or to refrain from doing something. So when there's an injunction, it means that either one or both sides have went to court. Now you have a judge involved, and now you have a court order giving some type of order to whether it's management or to the labor. Strike breakers, workers hired to do the job of striking workers until the labor dispute is resolved, called scabs by union. So what a strike worker is when someone else comes in to do your job while you are on strike. Now, this in the past sometimes can become dangerous because people don't like when others come in to do their job while they are on strike. Okay? Your wallet is almost empty, and bills for college expenses, food, and other expenses are keep piling up. Shop till you drop. A local grocery chain in your town is looking for workers to replace striking members of union food and commercial workers in International Union. Many other students at your college are supporting the strike, and many people from your neighborhood whose family depends on the income benefits work there. Will you cross the picket line and apply? What could be the consequence of your decision? Is your choice ethical? Hmm. So send me an email response pertaining to this ethical dilemma. Okay? Lockouts. So in 2011, the NFL did a lockout, resulting in the owners locking the players out of the team facilities for months. What effect do you think lockouts have on professional athletes as well as on sports facts. Okay? So stay tuned for the conclusion of our chapter 12 lecture.